said, we are going to talk about red flags. So these are going to be items that y'all, if y'all are going on a listing appointment, that y'all, are going to want to ask some questions. So that way you can help identify the red flags and, work with the title company, either prior to getting a contract or, as soon as you do get that contract. So that way they can start addressing those. So our agenda, we're going to talk about, why you need to first identifying the red flags, why you need to identify these so you can help, a smooth and have a smooth and seamless closing. And then also to avoid delays. Oh, sorry. So why does your title agent matter? Y'all want to choose a title partner that because y'all are working hard to get contracts, and you want to send your contract to somebody that that's going to pull everything together if there are potential problems. You want somebody that can address those and do it correctly. Your buyer and sellers also know that y'all are as the agent, y'all are the ones picking the title company. So in the end, a title company's performance can reflect negatively on y'all. So that's why you want to make sure that y'all are picking a good partner. And also you want to use a knowledgeable title agent, because you want somebody, again, that can help identify problems and then address those and resolve them quickly. You want somebody that can communicate effectively, efficiently, quickly. Y'all want to know right away when and if there are potential problems and how to correct those. So communication is key. And coordinating that transaction efficiently. And you also want clear guidance. If a big problem comes up, you want to ensure that your title agent, your escrow officer knows what to do to how to handle it, to ensure that you can get to closing. Nobody wants a contract to, get to the week of closing and then something happen and that title company or that title agent can't close it. I mean, that's a big problem. So all of those factor into, why you want to pick the right title company. So our first red flag, we're going to talk about business entities and why these may be a red flag. So when y'all are, when you have a seller that is, when you see a seller that's vested in title on the tax rolls, when y'all are writing a contract or you get a contract in, a few of the things that the title company is going to ask for right off the bat are the company documents. So y'all are going to want to make sure that your seller knows that they're going to need to provide those. I've had multiple instances where the parties can't find them. They were lost in a flood, or, they're packing and they're, because they're moving, they're packed up, they're going to need to get them. A title company is going to have to review those documents to ensure that the company has the authority to handle the transaction, who's going to sign on behalf of the company. Another big thing that could be a problem is if the company or the entity is not in good standing with the state. If they're not, they're going to have to work with a CPA to get their franchise taxes paid. And that may take a little while to get done. It could take 2 to 3 weeks to get the CPA to do that and then pay their franchise taxes so they can then get into good standing. If you have someone that's planning on forming an entity, that is also a potential red flag. It may take a little while for the attorney to prepare, corporate documents. Then there's, information or certificate of formation or whatever documents have to be filed with the state. I recently had a transaction where we waited, it was, I think, about 6 weeks for documents to come back from the state. So it did delay the closing. So if that's something that, you hear a buyer talking about, you may want to say, hey, get on that right away so you can, get everything done and filed with the state. Trusts. Trust can also be a red flag. Trusts are not legal entities in Texas. So they're operating through a trustee. And the trustee is the one that holds title to the property. So we're going to need copies of the trust. We're going to need sufficient evidence that the that the trust or the trustee has the authority to act on behalf of the trust. And again, those are documents that sometimes people don't have, they can't get a hold of, and there may be some tracking down of documents that somebody needs to do. And also with business entities and trusts, just kind of FYI, as far as title companies sending funds, title companies have a requirement that they're required to send the funds, so a wire or cut a check in the name of the seller. So if you have, Armstrong LLC, I should have an account that has Armstrong LLC on it. There's a few ways that you can kind of get around it. But in the end, that's a requirement that the title company has, and could potentially get hit if that file was audited and they didn't follow, that rule. Power of attorneys. If y'all know that one of y'all's parties are not going to be in closing or at closing, they're going to be out of the country, out of the state, y'all let your title agent know right away. There's some specific information that needs to go into the power of attorney. Y'all may run across a seller who has a prior power of attorney that's already been executed and notarized, but the title company is going to want that power of attorney to be specific to the property. And the majority of the time, a prior power of attorney is not going to be specific. It has to be in recordable format. And then also, if it's the buyer that needs a power of attorney, the lender is also going to have to approve that power of attorney. And then there are some different types of power of attorneys. You've got a general power of attorney that is it's just very general. It's got extensive powers. But what the title agent is going to be looking for is a durable or a limited durable power of attorney. So that is a power of attorney that is given, and the principal is allowed to act if the agent is disabled or incapacitated. And I've had underwriters turn down power of attorneys because it's not a durable power of attorney. And typically when I see people who present a power of attorney that has been executed prior to our transaction, it is not durable. So that is one thing that, the title company is going to have if it is a power of attorney. Marriages, lots of things here. So a marriage affects community property. So I'm sure y'all are all aware that we have, to deal with community property rights in the state of Texas. And it affects how things are inherited, potentially. So engaged people on a sell, it's not really, unless they're both in title, that is not going to really be a big deal. But engaged buyers, I had a closing just a few weeks ago where the parties were purchasing. It was a young couple, and the lender had them listed as a married couple, and they were not married at that point. And the loan officer told them, the loan officer was sitting in closing and told them that it wasn't a big deal, that it was okay if the deed of trust showed them as, you know, a married couple, and they weren't. And I said, no, it is a big deal. I mean, that's not accurate. You know, we need to get it updated. So you see things like that. You want the information to be accurate, and we would want to get updated documents. Name changes, as far as this, like if the seller, you know, we may ask for a marriage certificate. And a lot of times, you know, people will also get frustrated because they're vested in title individually, you know, prior to being married, and their, you know, spouse, their current spouse is not, you know, not on the loan. They're not vested in title. They don't understand why they need to, you know, that party needs to join in the transaction. But also, like I mentioned, community property, a title company also has to address homestead rights. So the property, if it was purchased prior to marriage, it would be separate property and not, you know, community property of the new spouse, but we have to address homestead rights of the new spouse. So that's why, you know, a new spouse would be required to execute the documents and sign the closing documents. Divorce and separation. If you have someone, a seller that's saying, you know, tells you that they're not, you know, finally, or not, their divorce isn't final, you know, your closer needs to know. They may not be willing to cooperate. You know, we may need to make special accommodations for them. And that divorce, there may be special provisions in the decree that the title company has to follow, but if it's not final yet, the title company is probably not going to follow those. Both parties would have to be in agreement as to, you know, how the funds were going to be distributed. Purchasing property during separation or divorce. So in Texas, if your divorce is not final and you purchase a new property that is going to be your homestead property, the lender as well as the title company are most likely going to require your spouse to, or your soon-to-be ex-spouse, to sign a few documents. They're going to at least need to sign the deed of trust. That's another one that people get very upset about, but because of the community property laws, and if with it being homestead, that spouse has to sign that deed of trust on a homestead property. Divorce and separation or settlement agreements. The title company will work with those. We would have to review any separation settlement agreements to see who was awarded what. There may still be some signatures that are required by the other spouse. It kind of just depends on those agreements and what they say. I've had several times where, you know, there's prenups, postnups, or just a, you know, property settlement agreement, and those aren't recorded in the public record. So typically the underwriter is going to want that spouse to still sign a deed and convey their interest. But it's a document that we would still need to see and review. Death. So this is a fun one. There's lots of questions that I think that should be asked if y'all are, you know, going on a listing appointment and a seller, potential seller, tells y'all that there's been a death. I think probably the first question should be, you know, did that person die with a will, and was the will probated? And then once you have those answers, then, you know, your title rep can kind of help you and direct you into what other questions may need to be asked or what information may be needed. If the person did not probate a will, then your title company is going to want or going to have to do heirship affidavits. Y'all may or may not be familiar with those, but it can be a lengthy process. Not all the time. It kind of just depends on, how many signers there are going to be, the situation. So each circumstance is, different. If there was only, a husband passed away, there was only one marriage between him and the wife that you're working with, then, it may be very easy. They have 2 children, the children are going to be, required to sign something. If there's prior marriages, any children from prior marriages, adopted children, they'll also be required to sign. So, sometimes people don't know where people are located, or it may take a little while to track people down or get people to respond. As far as heirship affidavits go, there has to be multiple signatures. You're going to have one interested party. So, if it's a spouse, that person, a child, someone that would stand to inherit from that person's estate. And then you're going to need 2 disinterested parties. That would be someone who wouldn't stand to inherit. So, a longtime family friend. You could potentially use, a cousin, an aunt or uncle, somebody has known that person for typically a minimum of 10 to 12 years is what the underwriters like. And, we can help get signatures, coordinate notaries, and so forth. If there was a will that was probated, but potentially in another county or state, if you inform your title agent that, there was a probate, but, we've told our examiner that we didn't pull anything up in Montgomery County when we did the examination. Then we've got to come back to y'all and say, hey, can you find out where the probate was done? Was it in another state? What county? And then we may have to order documents from another county, which that'll take a little bit of time. So if we know that up front, we can go ahead, get those ordered, and then provide those to our title examiner as soon as they come in. Because we have to have certified copies if something needs to be recorded. And those, there's FedExes that go back and forth and so forth. If it's more than 4 years and somebody wanted to probate, they could do the minument of title, which it's a process that they've got to, they'll have to work with an attorney and go through the court process, but we can, just do the heirship affidavit. Bankruptcies. This is another one. They can take, if it's a bankruptcy, a lot of times y'all may see bankruptcies that don't belong to the party that we would then get, a not same person affidavit for and file that of record. But if it is the party, there may be additional documentation that the title company asks for to verify that the bankruptcy has been closed. And if the property is part of it, or if it wasn't, if it's still an open bankruptcy, then the title company is going to need to work with the trustee that is, has been assigned to handle the bankruptcy. And a lot of times it can take, a little bit of time, week, 2 weeks to get a hold of that trustee, get the information, to them and back from them that's needed for closing. So the examiner is going to want to make sure that everything was handled properly if it did go through bankruptcy, and that's why they may ask for documentation from the seller if it's already closed. Foreclosures and tax sales. This is, for me, it would be a big red flag. Anything that has been sold at a tax sale has specific requirements that the person that was foreclosed on has a right of repurchase. So if it was foreclosed on at a tax sale and it was homestead property, under the law, the state allows a right of repurchase for 2 years. A title underwriter is going to require an additional 2-year period. So in order for a title company to ensure something purchased at a tax sale that was somebody's homestead, a title company will not insure for 4 years from the date of the tax sale. And then it would be a 6-month waiting per the state statute for non-homestead property, and the underwriter requires an additional 6-month period. They also want to make sure that proper notification was sent out. I've had multiple times where I've had to turn down a transaction because the underwriter didn't agree that the parties had received proper notification of the foreclosure. And then, is the sheriff's deed recorded yet? Those sheriff's deeds can take months to get recorded. So if you have something that has recently been foreclosed on, or I'm sorry, that was purchased at a foreclosure that was recent, the sheriff's deed, I mean, I've seen them take 3 months before. So those are very iffy. Regular foreclosures, if you're being foreclosed on by a lender, your mortgage, a lot of times there's additional documentation that the underwriter is going to want to see. They're going to want to know that, again, proper notification was done and that everything got paid off. So there may be a little extra legwork that the title company has to do to get all of that proper documentation. Liens and judgments. Y'all are probably most familiar with these, or what you may be familiar with is, mortgages, that's going to be a lien. You've got like abstracts of judgments, things, you may have a judgment filed from a tax suit. So there's a whole bunch of different kinds of liens and judgment. What it's against, if it's against their individual name, if it's filed against the property itself, delinquent taxes on investment properties, those are going to have to be paid off. So if there is a tax lien filed on other property, but we pull it because we're also searching the individual's name, those are going to have to be paid. The underwriter is not going to insure the transaction without those taxes being paid, because there is a abstract of judgment that is filed in the real property records. Child support liens, that's another one. A lot of them we can determine if they are the party or not just by getting some information, date of birth, social. We may ask for prior addresses just to confirm if they lived at an address that's filed on that abstract of judgment. That also, like federal tax liens, state tax liens, possibly from, not paying, taxes, state taxes, or workers' comp or something like that. So there's so many different kinds. And if a lien is filed and it's not our person or not our seller, then what we'll do is have them sign a not same person affidavit and then get it recorded at closing through our closing process. Lines of credit, those are other things that may show up. So if somebody has a home equity line of credit and they, tell you that they don't want to close it, the title company is going to require that to be paid off and closed, or they won't insure the property. Encroachments and easements. This, if y'all get an existing survey and, somebody tells you that they think that there's a problem, go ahead and send the survey over to your title company. Listen to them, listen to what they have to say, ask them questions. If they say that they were given, an easement, or that maybe they conveyed, a little bit of property to somebody, make sure you tell that to your settlement agent so that way they can inform the title plant when they're doing their examination. It may not be something that they're looking for. It may be easily missed by the examiner. And then if we've got to do a lot of back and forth, it may slow us down, or there may be some additional information that we need to get. We may need to get a variance, executed by the HOA and get that recorded. So more information is always, best, to provide as much as you can to them. Utility easements, if y'all have something, if your seller has built a porch, in a utility easement, we're going to take exception to it. I had a closing a few weeks ago where there was a 14-foot patio across the back of the house, and it was built completely in a utility easement. And I had to inform the buyer and that we were going to take exception to it, and they had to. Hello? Yes, do you have a question? Okay. So they're going to have to agree for the exception to that, for that patio. And if they're wanting the additional survey and boundary coverage, we're not going to be able to issue that if that's in that easement. We would take exception to that portion anyways. Guardianship, or if somebody is incompetent, if you're working with someone who, let's say you've got an heirship affidavit, and through the process you find out that there's one of their children is deceased, so their interest passes to their children, and they have a child that's 15. There has to be a guardianship appointed by the court. So any minors have to have court appointed guardian. That would take a little while. If someone is incompetent, this is probably more common than y'all think, but often, somebody will say, oh, they're in the hospital. Can you send a notary to them? Well, what's the circumstance? Do they know what's going on? Can they sign their documents themselves? Ask some questions, because a notary, isn't going to get a signature for someone who doesn't know what's going on. I've had several closings where that I've had to stop through the closing process. I'm literally sitting in the closing room, and I had to stop and ask some questions. It turns out that somebody has dementia, or they don't really understand what's going on, and they're the seller and, signing a warranty deed. So, at that point we have problems because, there could be another child that says that they were coerced into signing the documents, and you never know. So you want to make sure that people are competent and understand the documents that they're signing. Foreign sellers, if y'all are not familiar with FIRPTA, I would definitely get some information on it. So if y'all have foreign sellers, it is definitely important to let the title company know right away. There's IRS guidelines that the title company has to follow. So FIRPTA is the Foreign Investment in Real Property Tax Act. So this requirement is the title company has to withhold a certain percentage of the seller's funds to be remitted to the IRS for any potential capital gains that they may have to pay. So if your seller is not a citizen, then the next question that you want to ask is if they hold a green card status, if they are a resident alien. If they do not have their green card status, then they would be subject to FIRPTA. You can't really just ask if they have a social or a TIN number, because non-resident aliens can also get TINs. So just by having a TIN number doesn't make them not, they may still be required to or subject to the FIRPTA requirements. And it is, there are certain requirements that have to be met, and the withholding 15% is withheld, but if there's certain requirements, that amount can be reduced to 10%. So potentially it could be a lot of money, several thousands, 20, 30, $40,000. If you have a seller that says they do not have a TIN number, immediately tell them to reach out to a CPA, because a title company is going to tell them the same thing. So when the title company remits the FIRPTA withholding, if they don't have a TIN number to tie that money to, that it's going to get lost in the system. There's no way for them to track that, that money. If they don't have a TIN number, the title company shouldn't have a problem sending in W-7 information for the application for the TIN number with their documentation. So that's also an option. I've had multiple times where, they've worked with the CPA. The CPA has then sent all of the information, the application, the documents for the TIN number to me, and then I return them all together. And that's kind of what you want. You want, the title company to send that in together, because if the CPA does it, but they don't have a TIN number back yet, they may not close the transaction until they have that information. So just if that comes up, have them reach out to a CPA so they can get started on that. Translator, if somebody doesn't, speaks or is more comfortable speaking another language, we work with agencies that can provide translators. Here in my office, we have 2 Spanish speaking. One is a licensed escrow officer, and then another support staff, but that can also help, translate. But again, if there's another language, I can help and, bring a translator in. And that's it.
Like you know what you can and can't do, but in a classroom, that's the only thing.
Absent
Like,
buyers or sellers.
don't
So this just kind of goes back to, power of attorney, if you need to get that set up.
like she said, I feel like we're the redheaded stepchildren. Like y'all don't know when we coming back. Y'all can't put us on the same schedule.
Arrangements, I'm sorry, I lost my train of thought. So if a title company needs to make arrangements for, parties that are going to be absent. So like if we need to do mail out closings, we can do that. We need to coordinate with the lender. So there's a few extra steps that need to go into that, but just let us know in advance. It may be difficult for, a call the day before closing, to get things arranged. I may not, people may not be able to find a notary if it's late in the day or so forth. A title company, or me specifically, but most title companies probably, or that I'm familiar with, are going to require original documents back as well prior to funding. I myself, I will fund on copies in certain circumstances. I don't like to do it, but I will. But title companies are supposed to be in a position to record when they fund, and we cannot record copies. We have to have originals to record documents. So that's why they have that requirement. If I've had people, in prison before, that's, something else. If you've got a situation like that, there's workarounds for pretty much everything, but they just may take time. So again, ask your questions. The more information that you can provide to your title agent up front, the better. So that way they can start working on a solution. If you've got, parties that don't have identification, but want to sign with a notary, we have a solution, but we'll just have to, work around it. Wire fraud and cybercrime. I know that hopefully all of y'all are aware of this at this point, because I know it's been, lenders, title companies. I know y'all's brokers are probably talking about it. So just be aware and diligent, and, make sure that y'all are looking at email addresses and, before you're forwarding, information to your client, or, providing them with, or asking them to do something, and make sure that y'all are passing that information on to y'all's customers as well, so they can stay diligent as well. Oh, sorry, I messed that. Here's my wire fraud. Sorry. And that's it. Do y'all have any questions? If you want, y'all can unmute your your computer if you want, if you have questions.
This is Donna. I have a question.
Okay.
When you were talking about corporate documents, which documents are you requiring? Like
so for like an LLC, which is probably the most common, the title company is going to ask for the certificate of formation, which is the document that's filed with the state that, shows who the managers, the members are. And then they will also ask for an operating agreement, but if they have one, not all LLCs have them. They're not required to have them. So, some do and some don't. But they will ask for that and any amendments to an operating agreement if there is one. Something else that they're going to ask for, or that's good to have, it won't be necessary, but if they do have, so when they apply for their EIN number with the IRS, the IRS returns, just a one-page document that shows, what their EIN number is. It's always nice for the seller to provide that information to the title company. So that way the title company, knows exactly what it is. There's no, misconception about numbers and so forth. Because if in the end, when a title company is sending out 1099s, if that EIN or social or whatever, federal number that we're using, if that doesn't match up to the IRS's website, when we report that, then it gets kicked back to us. We have to do some, further calling and getting information from the seller. So it's nice if they have that to provide to us.
So certificate of formation and operating agreement if they have it, and then the IRS EIN paper.
Yes.
Okay. Not the articles of incorporation. That doesn't matter in this case.
If they have them, yes, the examiner would want to see them. But that would be for a corporation. An LLC would not have articles of incorporation because it's a different type of entity.
Okay. Thank you so much.
Any other questions? No? Okay. If, again, I know Tammy mentioned it, but I know that there were multiple people that joined after I think she mentioned this. If y'all need CE credit, if you will put your name and then your license number in the chat box, so that way we can get y'all set up for your certificate. Oh, and email address. She also does want your email address. Okay. If y'all do have any questions, after the fact, my email is here. Feel free to reach out to me. I'm always happy to answer questions for anybody, if it's just a general question, even if it's closing at another title company, but you're not understanding something, I don't mind answering questions like that as well. So always use me as a tool, reach out to me and ask questions if you have them.
Is your only office in the Woodlands?
Yes, currently, correct.
Okay. I did one transaction with you all last year and I was really impressed. Loved the service.
Good.
I was like, I wish I could use them all the time.
Good. Where are you? Where's your office at?
I'm in Sugarland.
Okay. So we're working on a it'll be a courtesy closing, but we want to do a little bit more than just sending a mobile notary to you. So we are working on getting a program set up to where an actual escrow officer comes out, does the closing for you. So that a way, since we only do have the one office, that a way we can open ourselves up and service a little bit of a larger area. So we've almost got that finalized, but here, very soon we'll be, we'll have that available as well. So it would actually be an escrow officer from our office that comes and facilitates the closing, not just a mobile notary that we have hired, through a service.
Okay.
Yeah. Let me see if there's any other messages. Okay, I think that's it. I don't think that I see any questions. Okay, guys. Well, thanks for joining. And again, if questions do come up, please reach out to myself or Tammy. And then Tammy will get y'all's CE credit or CE certificates to y'all. All right, thank you. Bye-bye.